Good evening, everyone. Jai Hind.
Good evening.
Let me begin with my introduction. I am DC Jain, Dharamchand Jain. I am 1991 batch IPS officer from Rajasthan cadre, and my last assignment was I am a retired officer. I retired from the Central Bureau of Investigation in October 23 as its special director, and I am with the Indian Police Foundation in the capacity of its chief operating officer. So, first of all, welcome each one of you who have already joined this webinar that we have today organized on the topic role of prison administration under the new law, procedural law, that is the Bharatiya Nagarik Suraksha Sanhita. Just a word about Indian Police Foundation. Those of you who may not be familiar with this organization, basically, this organization was established in the year 2015, 21st October 2015, and it was inaugurated by the then Union Home Minister, Shri Rajnath Singh. It is basically a multidisciplinary think tank of the Indian police. Idea is to kind of, like how to make our police more responsive, to work on areas relating to various kinds of police reforms, to help police in capacity building in by many ways, like organizing seminars, workshops, organizing training sessions for them. Then we also do police advocacy. We are not, I mean, senior retired police officers are members of this foundation. Not only the police officers, even the members from the other civil services, those who have retired from the post of cabinet secretary, union home secretary, and other important posts are members of our foundation. We also have significant members from the civil society, and so therefore we have a representative body of various sections of society. We not only have people from the police. We already have undertaken many activities relating to, like say, issues relating to police, relating to policing issues relating to women, children, trafficking, etc. And we are doing police reforms in certain a project on police reforms, internal police reforms in states like the state of Tamil Nadu, Punjab, Chhattisgarh, and we also wanted to do in Rajasthan. So that way, we are a very active body. And today's seminar, we have already done one program last year in Delhi on the new criminal laws, which was very well received. And on new criminal laws, this is our second program. And today, we are particularly going to talk on the role of prison administration in the new criminal laws. At this stage, our speaker of the day has already joined. So I welcome Dr. K.P. Singh, who has joined us. And before I request him to speak on today's topic, let me just introduce him to the audience. Dr. K.P. Singh is an IPS officer of 1985 batch, born on Haryana cadre. His last assignment or posting was DGP Haryana. But today's speaker is one person who has the unique distinction of heading all the wings of State Police of Haryana, whether it is the CID or the crime branch or the anti-corruption bureau or the human rights wing of Haryana Police. And above all, he has the distinguishing ability of heading the prison administration in various capacities as IGP, as IDGP, and of course the DG prisons. So that way we could not have found a better speaker than him for speaking on issues relating to prison administration, and he is well versed with the new criminal laws, its features. He is author of many books, more than 30 books he has authored on various topics like laws, police training, literature, etc. And as far as his association with the Indian Police Foundation is concerned, he is a life member of this foundation, and he's heading one of the verticals of this foundation on prison reforms. Therefore, sir agreed to our request. We welcome sir and we thank you for acceding to our request. All of you know the importance of prison administration. Prisons are one of the most important pillars of our criminal justice system, and we know there is a lot of there is a lot of things that can be done to improve or reform the prison administration. Today, we will see because we know these new criminal laws and particularly the procedural law has come into effect from the 1st of July 2024 last year. So obviously, we all are keen to know from Sir what all is there in the new criminal law, particularly the procedural law, that is the Bharatiya Nagarik Suraksha Sanhita, as far as the prison administration and the role of prison administrators is concerned. So we all know about one particular provision, I think, because that has been publicized a lot. That is Section 479 of the BNSS. We know that in the new criminal law, basically they have made a provision that whoever is a first-time offender without any previous conviction, this person, if he undergoes one-third of the maximum punishment of the offense for which this person is undergoing trial, in that case, just sorry for the interruption. Sir has already joined us. We have already welcomed Sir. Once again, thank you so much, and we welcome you to this webinar. I have already given introduction of Sir, and we could not have found a better speaker than you for speaking on this topic. I was just briefly mentioning one particular provision of the new criminal law, that is Section 479 of BNSS, wherein a provision has been made that under trial who is a first time offender without any previous conviction, if this person has undergone one-third of the maximum punishment for that offense for which this person is facing trial, then it is the duty of the superintendent jail to ensure that this person is released on bail by making an application in the court. And we know this is one provision which has come into effect retrospectively. This has been clarified by the Ministry of Home Affairs also, and in a landmark judgment in the month of August 2024, the apex court also has issued directions to this effect that this particular provision will also apply on all the pending cases under trial. So obviously the idea is to lessen the crowd in our prisons. And now I will not stand between you and the Dr. Kepi Singh. And if sir is ready, we may request sir to begin his lecture. Thank you so much, sir.
Thank you very much, Mr. Jain. Am I audible?
Yeah, you are audible, sir. Loud and clear.
Good, great. Mr. Ramachandran, sir, the president of IPF, Shri DC Jain, the CEO of IPF, and dear participants. It's my pleasure and honor both to discuss today what is the new role of prison officers under the new procedural law, that is the BNSS. As we all know, there are certain provisions, or there were certain provisions in the CRPC regarding prison administration. And basically, there were 3 chapters. One was regarding attendance of persons confined and detained in prison, meaning thereby when the court summons a person from jail to be produced before the court, it is regarding that. The second chapter was about provisions as to person of unsound mind, how a person who is of unsound mind and lodged in jail is to be treated. And the third chapter is execution of sentence, how a sentence awarded by the court is to be executed. So these were the 3 chapters in the old CRPC, which has been repealed by the BNSS. Now, there are certain additions in these provisions. There are certain new provisions which have been added. There are certain provisions which have been modified. Therefore, it is imperative that the prison officer as well as other stakeholders they must know what is new in these laws and where our new role is. We also need to understand what new the prison administrators are supposed to do under these new prisons law. What are the SOPs? What are the rules and regulations where change is required? So in the next 40-45 minutes, I will discuss those provisions. And then after that, we will have a question and answer session. The first change which the prison administrators have to understand is about the definition of gender in the BNS, in the criminal laws. And the definition of gender has been expanded to include the transgenders also. Therefore, now our classification of prisoners have to be modified. And we have to create a separate category for transgenders.
KP, would you like to also mix a little bit of Hindi?
Sir, definitely, sir, definitely, sir. So gender की definition को हमें अपने classification of prisoners में involve करना पड़ेगा. Gender को अलग से हमें transgenders के लिए अलग से provision enroll करने पड़ेंगे. Because अभी तक जो हमारे prison laws और manual हैं उसमें male और female prisoners का ही जिक्र है. Transgenders के लिए we require separate facilities because they are a vulnerable group. And how we will come to know whether a person is a male transgender or a female transgender? For our guidance, there is a law, that is the Transgender Persons Protection of Right Act 2019. And here, a DM, district magistrate, has been empowered on the basis of medical examination of a person, whether a person is a male transgender or a female transgender. And if you receive a person who is a transgender, first you have to determine whether he is to be put in the male category or in the female category, so that accordingly you behave with him and you provide facility with him or her. So this is the first change which the prison administrators have to understand. And as soon as a person enters jail, we get him medically examined. So ask your medical officer who is there in the jail when he examines such a person to determine whether he is a male or female, and then request the district magistrate to give him a status of a male transgender or a female transgender, and accordingly then provide him the facility. The second thing which the prison administrators must know is that the nomenclature of metropolitan magistrate in metropolitan areas, it has been done away with. अब पूरे हिंदुस्तान में एक ही नोमेनक्लेचर है क्रिमिनल कोर्ट्स की, जुडिशियल मजिस्ट्रेट सेकंड क्लास, जुडिशियल मजिस्ट्रेट फर्स्ट क्लास. मेट्रोपॉलिटन एरियाज में जो मेट्रोपॉलिटन मजिस्ट्रेट का जिक्र होता था वो अब BNSS में से हटा दिया गया है. A new change has come so far as the procedure of execution of sentence is concerned. Prison officers, those who are present, must be knowing that a sentence can run concurrently or consecutively. What do you mean by that? If there are more than one offenses in which a person has been convicted by the court in a case, then, for example, if a person has been convicted for 2 years under HART, 2 years under Arms Act, then how those 2 years plus 2 year sentence will run? It will depend upon how the court have said whether it will be running consecutively or concurrently. If the court says it will run concurrently, then both the sentence will run concurrently, and after 2 years the person will be released. But if the court says that it will run consecutively, then the person will be released after 4 years, that is 2 plus 2 after 4 years. So under the CRPC, there was a provision in section 31 subsection 1 that if the court has not given in the conviction order whether the sentence will run concurrently or consecutively, then by default and as a rule, it will run consecutively. But now in the new BNS, a duty has been cast upon the court under section 25(1) BNSS that the court will pronounce in the sentence itself whether it will run concurrently or consecutively. And accordingly, the jail superintendent has to run the sentence. If this provision has not been acted upon by the judge, then it is the duty of the jail superintendent, as soon as he receives the conviction order, to get the clarification from the convicting court whether the sentence is to run concurrently or consecutively. So this is slightly a change. In the earlier law, it was by default to run consecutively. Now it is the court to decide whether it will run consecutively or consecutively, and the court has not, if the court have not decided it, then it is the duty of the jail superintendent to get this clarification. The powers of the court have also been increased so far as fine is concerned. The judicial magistrate second class now impose fine up to rupees 10,000. Judicial magistrate first class can impose fine up to rupees 50,000. Community sentence can be imposed by both these type of magistrates. An important change has come so far as community service sentence is concerned. As we all know, a new type of sentence has been prescribed under the BNS, that is community service. And it is a substantive sentence at par with any other sentence. What is a community service sentence? It has not been defined in BNS, but it has been explained in section 23 of the BNSS. An explanation has been added after section 23 BNSS, which define community service as a court-ordered work that is for the benefit of the society and for which no wages will be paid. Here, there are 2-3 observations which I think will come to the scrutiny of the court. What can be a court-ordered work? And the High Court, especially the Judicial Academy Bhopal, National Judicial Academy Bhopal, they are already on the job to work out what should be the court-ordered work. And accordingly, they have to revise, the high courts have to revise their high court rules and order for the guidance of the judicial magistrate, so that they order a work which is for the benefit of the to the community as per the rules and order which is to be framed by the high courts. Another observation about this provision is it not hit by Article 23? क्योंकि आर्टिकल 23 कॉन्स्टिट्यूशन ऑफ इंडिया में बेगार को प्रोहिबिट किया गया है कि अगर आप किसी से कोई काम लेंगे तो उसकी आप वेजेस देंगे. हम जेल में भी अगर किसी रिगरस इम्प्रिजनमेंट वाले किसी कैदी से काम लेते हैं तो उसको भी वेजेस देते हैं. तो नाउ इट इज टू बी सीन हाउ द कोर्ट डिसाइड इट इन फ्यूचर व्हेन दिस मैटर कम्स बिफोर द कोर्ट. Another lacuna in this provision which I could find is that nothing is mentioned how this sentence shall be executed. There is a chapter in the old CRPC and even in the BNSS which is titled as execution of sentence. और इस चैप्टर में ये बताया गया है डेथ पेनल्टी कैसे एग्जीक्यूट की जाएगी, कैसे वारंट इश्यू होगा, इम्प्रिजनमेंट का सेंटेंस कैसे एग्जीक्यूट होगा, कैसे वारंट उसका इश्यू होगा. बट दे फॉरगॉट perhaps, or it was an oversight, to mention about community service sentence. I think after section 459 of the BNSS, they should add a section how the sentence of community service shall be executed. And I think in due course, when the amendment will be taken up or this matter will be brought to the notice of the legislature, I think this clarification should come there. Till now, the courts are ordering different kinds of authorities, including police officer, to serve or to help serve the community service sentence or monitor the serving of community service sentence, which in my opinion is not correct. There should be an authority to whom the warrant of service of community service sentence should be issued, and that authority should only execute it. And in my opinion, I think the jail authority should be assigned this work, because the record of crime and criminals is to be maintained either at the jail or at the village crime notebook of the police station. But clarifications are needed here, and BPRND is already on the job. Till such time it is finalized, it is the court who are ordering who shall execute this sentence. Handcuffing. Handcuffing was a rule under police manual as well as under the prison manual, and not handcuffing was an exception. But after the Citizen for Democracy versus State of Assam in 1995, handcuffing was an exception and not handcuffing was a rule. Now, keeping in view the difficulty which was being faced by police officer, this provision has been amended and under the certain provisions, section 43(3) of the BNSS, now police officer can handcuff a person under certain circumstances. But mind it, it is to be clarified for prison officers that they cannot handcuff a person without the permission of the court. Whatever relaxation has been given under the new laws, it is for the police officer. For prison officer, if they want to handcuff a person inside the prison or whenever the person is in their custody, they have to take prior permission from the court. Another important change for the prison officer is use of mobile phone inside the prisons. Mobile phone is a prohibited item under the jail manual and under the jail rules. A person cannot take a mobile phone inside the jail. But if there is some investigation which is to be done by police inside the jail premises, inside the jail, they have to make certain investigations. Now it is made mandatory for the investigating officer to take video recording of the scene of crime as well as of search and seizure, and has to send it to the judicial magistrate or to the executive magistrate as the case may be. So police officers who are investigating a case inside the prison, they are to be allowed mobile phones because it is mandatory on their part to record audio visually the scene of crime as well as search and seizures. So the prison rules in this regard are to be modified, or an exception is to be created to that effect, that if a police officer is visiting prisons for the purpose of investigation, for the purpose of search and seizure, then he is to be allowed mobile phone inside the prisons. This is an important aspect of prison administration, because police and prison officers, they are generally, in order to put them on defensive, the prisoners and the criminals, they file criminal istighasas and criminal cases against them, private complaint cases for alleged beating or for alleged misbehavior, etc., etc. Under the earlier provisions, under section 156(3) CRPC, the magistrate used to order registration of FIR. But now an exception has been created under section 175, subsection 4 of the BNSS, that if a case is to be ordered by the magistrate under section old 156(3) CRPC and new 175(4), then the magistrate cannot order it, registration of FIR, unless he has given an opportunity to the accused person for representing his case. That is, without hearing the person, the magistrate will not order registration of an FIR against a public servant, including police and prison officers. And secondly, the second requirement is that the magistrate should take a report from a superior officer to that alleged accused person, so that the magistrate is in a better position to appreciate under what circumstances the person might have misconducted during the discharge of his official duties. So this is a safeguard for prison officer as well as police officer and other public servant, which the prison officer must know in capacity of their administrative authority. Another important provision which generally the prison administrator come across is copies of the documents to the accused person. Sometimes the accused is there in the jail and he does not have the copy of the challan or the copy of the document which he required for his defense. Under the old CRPC, it was the duty of the court under section 207 CRPC to supply the copy. But now under section 193(8) of the BNSS, it is the duty of the police investigating officer to provide copies of the challan and other document to the accused person. And he can supply it in PDF form, in electronic mode. So if a prisoner inside a prison is not having copy of the challan or document, what the prison administrator can do is he can ask the court that please direct the police to supply these copies to the accused person as well as to the lawyer of that person if he is not having that copy. So this is a change. In administrative capacity, the prison administrators have to know another change, that is about prosecution sanction. The prosecution sanction, which was required under section 197 CRPC, which is now 218 BNSS, there was no time limit prescribed for according that prosecution sanction. Now a time limit of 120 days has been prescribed. The administrative authority have to act within 120 days, whether to refuse permission or to grant permission for prosecution. And if the authority fails to exercise that power, then it shall be treated as if it is deemed to have been given sanction. So the district jail superintendent, who may be an appointing authority for warden and lower staff, they must know that if they come across a case, then they have to act upon it within 120 days. Otherwise, they forfeit their right to take a call on it. Sometimes the private person, they file complaint cases against prison officers. And in Hindi, we call it generally in North India, istigasa, private complaint cases. So under that provision also, two safeguards have been provided for public servant, including prison officer, that the officer should be given an opportunity before being issued summons. Secondly, a report from his superior officer should be obtained to know in what circumstances the allegations have been leveled by that person against the public servant. So this is a safeguard, important safeguard, because many prison officers and many prison lower staff, they suffer such type of complaint cases against them by motivated prisoners. There's a provision to enable audio-visual recording of evidence, and for the enabling provision is in section 254 BNSS. And second part of this section is that now the public servant, they can depose before the court through audio, video, electronic means. What is important before going for audio, video recording of evidence or providing that facility? The facility is to be a notified place. We are using jails for recording evidence. There are studios inside jail. But please see, as jail superintendent or as jail official, whether those places have been notified by the government as audio-visual facility or not. Because under section 265 of the BNSS, such a facility is to be notified by the government as a audio-visual examination facility. Only then such a facility is authorized or is to be legalized to be used as audio-visual authorities. To my notice, this has not been done, and now we should apply to the government that they should authorize the facilities inside the prisons as well as outside the prisons, if they have established some, that those places should be notified by the government. There is a provision in the old CRPC that state government can prohibit removal of a prisoner or a class of prisoners from jail. For example, the court issues a warrant to the jail superintendent that produce such and such person before the court. Central government as well as state government now, earlier it was only the state government, now it is both the central government and the state government authorize a jail superintendent not to produce a person before the court, even if a warrant has been issued, under certain circumstances. And what are the compelling circumstances? The compelling are depending upon the nature of offense, depending upon the situation, law and order situation or public order situation, and in public interest. Both the state government and the central government can direct a jail superintendent that such and such prisoner or a class of prisoner should not be moved out of jail. So earlier it was only the state government, now central government has also been authorized. Sometimes a report of a public servant, including jail superintendent or including jail official, is called in evidence in the court, and the court want to examine that authority who have produced that report. Suppose the person have been transferred out, or he has retired, or he has died, or he is not easily available, then the court issues summons to the next predecessor to come and say something or depose on that report. Sometimes there were difficulty. The officers, they were refusing that it was not my report, how should I go? And they used to send some lower functionary to the court. Now, an enabling provision has been made under section 336 that court can summon to his predecessor to come and depose on that report. And that deposition can be through audio, video means also. A new provision has been made and the jail superintendent must know it because they will be facing certain situations or the court orders in this regard. Under section 311A of the old CRPC, the magistrate can order a person to give his specimen signature as well as his handwriting samples on the request of the police officer. But the condition was that the person should have been arrested by police. Now there are certain change in this provision. The change is that the court can also order such a person to give his voice sample as well as his finger impressions also. These two things were not there under section 311A. And suppose a person is confined in jail and police need to take his voice sample and police need to take his finger impression, then the police will get a production warrant issued to the court. So the jail superintendent must know that for the purpose of voice sampling and finger impression also, now a person who is confined in jail can be summoned by the court to give those samples. Another, it is not necessary for the jail officers to know, but for general knowledge, I must tell now, earlier under 311A CRPC, it was mandatory that the court could order giving of handwriting sample and specimen signature only a person who has been arrested in the case, not to the suspects. Now a proviso has been added that court, if they feel that it is necessary, they can ask even a person who is a mere suspect who has not been arrested to give his finger impression, specimen signature, handwriting and voice samples. The word lunatic, it is written in the CRPC as well as in prison manual on so many places. The word lunatic now has been removed from the dictionary of the prison manual and the procedural law, and the word is replaced with the word person of unsound mind. So wherever it is occurring in our jail manual, it should be got replaced with a person of unsound mind. Under section 390H of the BNSS, a witness protection scheme is to be notified by the state government. There are so many prisoners inside the prisons who are threatened either by the rival gangs or by some other enemies. So a witness protection scheme can be invoked to protect those persons when they are going out of the prisons in the court. So if a person is facing some danger from his rivals and the jail superintendent knows about it, and generally the jail superintendent, they come to know about it, they are supposed to get the witness protection scheme invoked so that the person is not attacked outside the jail by anybody. The Supreme Court in Mahendra Chawla versus Union of India has already given a draft witness protection scheme, and the state were asked to have their own state protection scheme. Some of the states have already notified it, majority of them have not, but the jail superintendent is well within his right to ask the session judge as well as the superintendent of police to provide adequate protection to the witness who is inside the jail and is being taken out of the jail if the jail superintendent is apprehending that there may be some danger to the life of that person. Another important change which as prison officer we must know is about the provision of remission and commutation of sentence. It is very important to understand what is the difference between remission and commutation and what is this concept. The concept revolves around how the sentence of a prisoner can be shortened, how that person can be released before he completes his term of sentence. And let me explain here two concepts, because then it will be easy for me to explain the concept. That is remission. First is remission. Remission means reducing the amount of sentence in the same category of sentence. What does it mean? If a person has been convicted for 10 years, then his sentence can be reduced to 5 years, 3 years, 2 years, same category, without changing the category of sentence. Person has been convicted, say for example, for 1,000 rupees fine. The fine can be reduced to 500. So this is called remission. Remission means reducing the sentence in the same category of sentence without changing the nature of the sentence. And it was explained so by the Supreme Court in Prem Raj versus Delhi administration, because in law, it has not been explained. Another concept which I used is about the commutation of sentence. Commutation means changing the form and nature of the sentence. What does it mean? It means the form and the type of sentence is to be changed. For example, a person has been convicted to death imprisonment, to death sentence. Then that sentence may be changed to life imprisonment or to imprisonment. Or for example, if a person has been awarded sentence of imprisonment, then that can be changed to fine. So this is called commutation, when it involves changing of the nature of sentence. And there are two different provisions under section 473 and 474 of the BNSS, which are corresponding to section 432 and 433 of the CRPC. So about the provision of remission, there is no change, but about the provision of commutation, there are certain changes. And there are a lot of confusion about that. Lot of confusion, not only among the prison officers, among the court even, because these terms, commutation and remission, they have been used interchangeably. The court have been using these terms interchangeably because the matter has not been presented before the court properly, maybe because of lack of oversight or because of lack of some understanding of the proper law. The remission is used in two different ways. There are some remissions which are granted by jail officials. Sometimes remission is granted by the state government. Sometimes remission is granted by the governor or the president. There are three different powers and they are independent of each other. So there are certain confusion about it. Let me not go into the details because time is very short, but let me find out what is the change in the provisions of commutation. And the change is in the form of section 474. Under section 474, the government, state government, is authorized to commute the sentence of a person without his consent. Suo moto, the state government has been given power to commute the sentence. And commute the sentence, death imprisonment to life imprisonment to a sentence of more than 7 years, a sentence of imprisonment from 7 or upward to a sentence up to 3 years or more, or a sentence of imprisonment up to 7 years to a sentence of fine. What does it mean? It means if there is a prisoner inside the jail and the government decides that they want to commute his sentence, then they can commute the sentence as per the provisions of section 474. This power was given by the British under section 402 of the Act CRPC, which was applicable at that point of time, the CRPC of 1998. Under that provision, the Governor General in Council was given power, as well as the state government, if that is there, were given power to commute the sentence. And it was basically to empower the Governor General so that he can commute the sentence to win favor of the person in favor of the British Raj. When we became independent, this power was retained in the CRPC 1973 to prevent ill effect of incarceration on long-term prisoners. And now, in one judgment, Justice Hemant Gupta has said that this power should be used to reduce overcrowding from the prisons also. So, in this section 474, the government have now curtailed the power of the state government to some extent. Earlier, the state government was empowered to commute the death sentence to any sentence, including fine. So great power. Now, the power has been reduced that it can be commuted now up to life imprisonment only. And life imprisonment could be commuted to any other lower category sentence by the state government under the previous law. Now, the minimum sentence for such a person is 7 years. Life imprisonment cannot be commuted to less than 7 years imprisonment. So certain changes have been made. What is required for the prison administrators under this provision is that they have to draft a fresh commutation policy, which is called premature release policy. And they have also to prepare a standard operating procedure for exercising the power under section 473 for remission of sentence. It's a long discussion on it. In short time, it is very difficult to explain. But the point which can be brought home is that we have to draft a new premature release policy for remission and commutation under these new provisions. Mr. Jain was telling about how long a under trial prisoner can be detained in prison. That is section 479 of the BNSS. There was a section in 436A CRPC whereby a person who has served half of the sentence prescribed for that offense as an under trial prisoner used to get a right to be released on bail. There are certain changes now in this provision, and the power of jail superintendent have been given in that reference. Some provisions which the jail superintendent have to implement. Under section 436A, if a person who is not awarded or has not committed an offense which is punishable with death or life imprisonment, then he can be given benefit under this provision. Earlier, it was only for those persons who have not been awarded death sentence. But now the life imprisonment has also been added in that category, meaning thereby the scope of this section has been reduced. So now only those prisoners who can be awarded term sentence can only get benefit of bail under this provision now. So the power has been restricted. The another restriction is that if a person is facing more than one charge in one offenses in a case, then he is not eligible to be released under this provision. The third inability is that if a person is facing more than one trial in more than one case, then he is also ineligible under this provision. So the scope has been reduced tremendously, but a responsibility has been cast upon the jail superintendent that if a person is eligible under this provision to be released on bail, then the jail superintendent shall file an application in the trial court for his release. So this is a duty cast upon the jail superintendent. It is now up to the jail superintendent or the duty of the jail superintendent to see whether any prisoner who is under trial in his jail is eligible to be released on bail under this provision or not. So it is a duty cast upon that jail superintendent. For the first time offender, this sentence is not 1/2, it is 1/3. And he can be released on personal bond also instead of bail. So these are the changes which the jail superintendent must know. New provision has been added in section 472, and this is the last provision which I am going to discuss. After that, we'll be open to question and answer session. That is about the mercy petition in death sentence cases. Hitherto, there was no guideline how mercy petition for death row convict are to be processed. But now a new section in CRPC has been added, section 472, which gives a procedure how mercy petition in death row cases is to be handled. And the duty is cast upon the jail superintendent under this provision as well, which was not earlier there in the law. And what is that duty? Now, let me tell you. As soon as a person, his appeal or his mercy petition is to be filed, or his sentence is to be, or he's supposed to, he want to file a mercy petition before the governor or before the president, then the duty of the superintendent jail is to inform that person as soon as his final appeal is disposed of against him by the Supreme Court within 30 days from the date on which this appeal has been dismissed. The Supreme Court has to tell to the person who is inside the jail that your appeal has been dismissed by the Supreme Court and you have a right to file a mercy petition. First, he has to file a mercy petition before the governor. And if it is rejected by the governor, then before the president. A duty is cast upon the jail superintendent that if there are more than one death row convict in a case, and suppose one has filed a mercy petition, the another has not, then it is the duty of the jail superintendent that he should file the documents relating to that person who has not filed that petition also to the governor, so that the mercy petition of both these cases, of both these persons, is decided at the same time by the governor. And it was basically to avoid a situation whereby the convicts were taking advantage of a lacuna in law. What was the lacuna in law? The law says that even if one mercy petition is pending, the person who has been convicted along with that person cannot be hanged. So how the advantage was being taken by the convict? Suppose there were more than one death row convict in a case, then one will file a mercy petition now, and it takes 5 years, 6 years, even 10 years to be decided. As soon as his mercy petition is rejected, the another one will file. So it used to delay the proceedings. And in 2014, Supreme Court gave a judgment in Shatrughan Chauhan that if there is a delay in execution of a death sentence, then that sentence will be commuted to life imprisonment. And in 2014, 37 such death row convicts, their sentence, capital sentence was commuted to life imprisonment, including the punishment to Rajiv Gandhi's convict, 7 convict of Rajiv Gandhi. So in order to avoid that delay so that the convicts cannot take advantage of that, it has been made mandatory that the mercy petition of all the convicts is to be filed to the governor or the president. So it is the duty cast upon the jail superintendent that he decides or he submit the document of all such convicts together. Last but not the least, I will conclude this presentation by mentioning another provision. In section 435 of the CRPC, there was a provision that if a case has been investigated by CBI, or if the case relates to damage to the property of the central government, or if it is a case related to the officer of the central government, then remission and commutation of sentence cannot be done by the state government without the consultation of the central government. So in Rajiv Gandhi's case, there were certain difficulties and the matter was referred to the constitutional bench, and then the Supreme Court held that the word consultation should be changed to the word concurrence, meaning thereby state government are not authorized to commute or remit the sentence of the convict who have been convicted in a case which was investigated by central government agencies, or where the damage to central government property is there, or the convict is a central government servant. So this is the new change. So I end up my lecture here, and now I am open to the discussions.
Thank you so much, sir. I think it was a very lucid and detailed presentation. आपने बहुत ही सरल भाषा में सब लोगों को समझने आ सके उस हिसाब से आपने मेरे ख्याल से सारे जितने भी सैलिएंट फीचर्स हैं जो बीएनएसएस में जो नॉलेज के हिसाब से भी लोगों को जानना आवश्यक है, और उसके अलावा जो particularly those officers who are directly entrusted to the role of prison administration, उनके लिए तो बहुत ही महत्वपूर्ण है, उपयोगी हैं. So I think in the due course I will try to summarize, but before we do that, we will throw the floor open for questions. हमने ऑलरेडी लिख दिया है चैट बॉक्स में कि अगर कोई क्वेश्चन है तो या तो आप चैट बॉक्स में टाइप कर दीजिए, मैं पढ़ दूंगा, या अगर कोई इन पर्सन पूछना चाहते हैं, खुद बोल करके पूछना चाहते हैं, इफ यू वांट टू स्पीक एंड आस्क देन प्लीज रेज योर हैंड so that our administrator will unmute you and then you will be allowed to ask the question. So you are free. Now the floor is open for question answers. Please raise your hand or otherwise type in your question in the chat box so that it can be read over to the speaker and the speaker is requested to answer. Okay, so we have the first question, sir. How the community service as a punishment is to be executed? That has been asked by Principal PJTS.
Very good question, and I have already raised my apprehension about it. There is no clarity in the law, and a new section under the chapter of execution of sentence under the BNSS is to be inserted, how it is to be executed. But till now, the court have used their discretion. I have written an article on it in which a Jammu and Kashmir court have ordered the SHO to monitor the execution of community service sentence. In one such case, they have ordered the municipal commissioner to execute the sentence of community service. In one case, even they have asked the Gurdwara Granthi to monitor that execution of sentence. So there is no guideline or clarity so far. And for that reason, I have already stated in my presentation that a new section is to be inserted because the sentence awarded by the court are to be executed as per the warrant issued by the court. And the warrant to whom it can be issued, it is to be prescribed under the BNSS. So there is a need that the section should be there in place. I think in due course, when the matter will be brought before the legislator or before the authorities who matters, this will be rectified. But in my opinion, I think they should have a community service officer in the jail department itself. And the jail department should be allowed to monitor it because they are authorized or they are trained how to receive a warrant for execution of a sentence, how to record it, how to report it back to the court, because a substantive sentence which has been passed by the court is to be reported back also to the court that the person has served that sentence. And it is to be recorded in the record also for future references. So I think there is no clarity about it. And BPRND as well as the National Judicial Academy Bhopal, they are already working on it, how to deal with this subject.
Thank you, sir. This next question is from Shri Rakesh Verma, and he wants to know, KP sir, is there a hope to decongest the jails? Tariq pe tariq culture persists unendingly.
A very good question. Overcrowding can be reduced if the court exercise their jurisdiction properly to adhere to the rule, no jail but bail. What the court are doing, they are sending everybody to jail without adhering to that rule, firstly. Secondly, the police also have to exercise their discretion under the new law not to arrest everybody whom they have authorized or they are authorized to arrest. Without arrest also, they can send challan to the court in petty matters. And nobody else than Mr. Jain can know about it. CBI submit challan to the court without arresting in so many cases. So first, police should exercise their power to arrest judiciously. They should not arrest at the drop of the hat. And secondly, the court should not refuse bail as in a matter of routine. So these are the two things. And third thing is about the release of the long-term prisoners who are serving sentence as premature release cases, for which I have discussed the provisions of Section 474. But the first thing is police and the trial court, they have to exercise their discretion to arrest and to release on bail respectively, judiciously as well as on need-based basis, not on routine basis.
Thank you, sir. Amongst the audience, we have Shri P.V. Ramashastri, who is an IPS officer of 1999 batch. Very recently, sir has retired as DGP Prisons Uttar Pradesh. He had certain observations to make, I think, regarding the practical difficulties being faced by the field officers. So we can have a few observations from sir. I would request him to please keep it in brief.
Firstly, let me express my gratitude to Dr. K.P. Singh sir for his very lucid explanation of the changes. Two, three observations, sir. And my request is also to the president and the COO of the foundation. If these can be taken up with the government. One practical difficulty we faced is about 479. 436A was very simple. But the 479, if you read the section, is very complicated in its language, and often it is liable for differential kinds of interpretations, particularly with respect to eligibility of the people who have more than one offense committed by them. What we have been doing is a liberal interpretation. अगर strictly देखेंगे तो कोई जीरो होगा, कोई एलिजिबल ही नहीं हो पाएगा। हमने क्या किया है कि एक जिनके जो पहले कन्विक्ट हो चुका हो, जिनके पास अभी कोई ट्रायल या इंक्वायरी या इन्वेस्टिगेशन पेंडिंग ना हो दूसरे केस में, ऐसे सब लोगों को हमने हाफ के लिए एलिजिबल करके पेश किया कोर्ट में और कोर्ट्स ने भी एक्सेप्ट कर लिया। मैं फ्लैग इसलिए करना चाहूंगा कि गवर्नमेंट ऑफ इंडिया लेवल में इफ दैट कैन बी प्रोजेक्टेड। सेकेंडली, जो एनआईसी का जो ई प्रिजेंस का जो पोर्टल है उसमें ऑटोमेटिकली फ्लैश हो जाते हैं एलिजिबिलिटी लिस्ट। सो ऑटोमेटिकली जो ई प्रिजेंस में जो फ्लैश हो रहा है और हमारे इंटरप्रिटेशन से जो हो रहा है, देयर इज अ मिसमैच। सो दैट इज वन इश्यू which needs to be taken up. Sir, secondly, आपका 269B का अभी जो 304 में वेरिएंट है कि प्रिजन ऑफिसर्स अब्सटेन करेगा वारंट एग्जीक्यूट करने में अगर कोई ट्रायल चल रहा हो जिसमें चार्ज फ्रेम हो चुके हों, तो वो लेकिन ऐसे तो प्रैक्टिकल नहीं है, दूसरे भी केसेस चलते हैं और भेजना तो पड़ता ही है। तो फिर इसमें अगर ये 269B अगर ओमिट हो जाता या कुछ रिस्ट्रिक्ट हो जाता तो बेटर रहता। नहीं हुआ तो मे बी स्टिल दैट कैन बी टेकन अप सो दैट देयर इज सम क्लैरिटी विद द प्रिजन ऑफिसर्स की कब एब्सटेन करें वारंट एग्जीक्यूट करने में, कब एब्सटेन ना करें। तो आई विल कीप इट ब्रीफ सर। दो तीन चीज अलग है सर। डॉक्टर के.पी. सिंह सर से मैं 1-to-1 भी एक बार समय मिल जाए तो मैं डिस्कस करना चाहूंगा। और आई विल कीप ओनली वन मोर पॉइंट। रिवीजन आपका जो कम्यूटेशन और रेमिशन में तो दैट देयर इज एन अवॉइडेबल डुप्लीकेशन which could have been set right in the BNSS because if I am a convict, मेरे लिए आप मुझे रिमिट करो, कम्यूट करो, दोनों के समय आई डोंट सो मच बॉदर अबाउट इट, मुझे तो फायदा मिल जाएगा। दैट्स ईदर केस मुझे ही फायदा मिलना है। तो जब हम रिमिशन पॉलिसी बनाने लगे एज पर द ऑर्डर्स ऑफ द ऑनरेबल सुप्रीम कोर्ट व्हिच वी मेड, फिर हमने कम्यूटेशन पॉलिसी नहीं बना पाए बिकॉज गवर्नमेंट सेड दैट आपको रिमिशन के लिए कहा, रिमिशन ही कर लो। जो इसके लिए भी अगर डॉक्टर के.पी. सिंह में लाइक टू have some solution how to go about it. Sir, ये 3 points.
Yes. May I respond? Jain sir?
Yes, sir. Please go ahead.
So thank you very much. And first of all, Mr. Ramasastri, I wish you a happy retired life. We met in BBRNT about a couple of months
Yes, sir.
back.
Yes, sir. Thank you, sir.
There are three queries, and I will like to respond one by one. First thing is about release of under trial prisoners on mandatory bail after they have served half of their sentence as under trial prisoners. I think if we read the provisions literally, there is no confusion. The confusion has been created when we apply it because we feel that it is illogical. The conclusion which we get from literal interpretation is illogical. It is being too harsh on them. But we have no option. We are field officer. We are not the court which can interpret the law. We have to read it as it is unless the High Court or the Supreme Court interpret it the way Mr. Shastri has said. So unless and until there is an interpretation by the Supreme Court at All India level about the interpretation of this provision, as Mr. Shastri has said, it is dangerous to adopt our own interpretation because that would be illegal. This is my observation. You may differ. You have a right to differ. Second thing is about 269B, which he has mentioned. Suppose a trial is going on before a trial court, and some other court want presence of that accused person in that court. So the court or the jail superintendent can refuse that I am bound by that court that he is under trial in that particular court, so I will not send you to your court to that person. I think it will land the jail superintendent in trouble. So he has very rightly mentioned that some clarity is to be there. And I think the clarity will be that the jail superintendent, in my opinion, as I could think, because the trial continues for decades, 10 years, 12 years, even sometimes in 20 years. So you cannot bound a prisoner to one single case for 20 years that he should not be produced in any other court for any other trial. And the gangsters, they face sometimes dozens of cases. So you cannot do that because the trial has to go in all the cases depending upon the wishes of the court. So I think what Mr. Shastri has said has a merit and it needs to be decided by the legislature as well as the authorities. The third question is about remission and commutation of sentence. I have explained it a number of times in the conferences of jail officer. Remission और commutation के purpose अलग-अलग है और ये दो अलग-अलग power 473 जो पहले 432 हुआ करती थी उसमें remission decide किया गया, define किया गया है और remission का purpose है individual basis पे remission because section 473(2) says that the case is to be taken up from case to case basis, not as a policy, case to case basis. For example, there is a pregnant woman and that pregnant woman is there in the jail and she wants that let her go out, her sentence should be suspended and after the child is of 1 year old or 2 year old, I'll come back and serve my remaining sentence. And she wants suspension of sentence. Here, 432 or 473 will come into picture. That is remission. If suppose there is no male member remaining back in a family to take care of the infants who are there, and all the male and female adults, they have been convicted and they are in the jail. So 1 or 2% of those convicted person can go for remission of their sentence or suspension of their sentence for the time being so that they can take care of those children and they can come back again after a particular period and then can serve the remaining sentence. This is suspension under 432. Remission is also for that purpose only. For example, a person is there for 7 years of imprisonment inside the jail and certain things happened in his family and he requests to the government that please my sentence of 7 years should be remitted to 5 year or 3 year so that I can go out and take care of that emergent situation in my family. So the government, in public interest and in the interest of that person, on case-to-case basis, can consider his request. That is remission. What is commutation? Commutation was a provision which was made by the British under section 402 of the British period CRPC, to give that power to the गवर्नर जनरल काउंसिल कि वो जिसको चाहे अपनी मर्जी से जब चाहे छोड़ दे, वो अंग्रेजी राज की थी, ताकि जो फ्रीडम फाइटर्स थे या और दूसरे लोग थे उनको वो कोई कंसेशन इस किस्म का दे के अपने साथ मिलाकर अपने हित साधना कर सके। 1973 में जब नया सीआरपीसी हमने लिखा तो उसमें उसके साथ एक पिनोलॉजिकल एस्पेक्ट और जोड़ दिया गया कि जो लॉन्ग टर्म इनकार्सरेशन का इल इफेक्ट है, लंबे समय से कोई 10 साल से 15 साल से है तो उस पर इल इफेक्ट आ जाता है इनकार्सरेशन का, तो उस इनकार्सरेशन के इफेक्ट को मिटिगेट करने के लिए क्यों ना हम लोगों को जो लॉन्ग टर्म सर्विंग सेंटेंस वाले हैं, लाइफर हैं, उनको हम अर्ली छोड़ दें। और वो अर्ली डिसाइड किया गया कि 14 साल में उनका केस कंसिडर करके छोड़ दें। अब इसमें एक डायमेंशन सुप्रीम कोर्ट ने और जोड़ दिया, 2022 का शायद जस्टिस हेमंत गुप्ता का केस है, कि ओवर क्राउडिंग कम करने के लिए भी लॉन्ग टाइम प्रिजनर्स को, जो लाइफर्स हैं, उनको हम प्रीमेच्योरली रिलीज करें। और जेल में जो कन्विक्ट होते हैं, मिस्टर शास्त्री विल एग्री विद मी, 66% उनमें लाइफर होते हैं। जो कन्विक्ट जेल में है वो 20 से 25% ही हैं, बाकी अंडर ट्रायल हैं। और जो कन्विक्ट भी हैं उनमें 66% दे आर लाइफर्स। So it was a provision for those persons, lifers, so that they can be released from the jail and it can help in reducing the overcrowding. जो अब 474 में हम प्रोविजन लेके आए हैं उसमें मेरे हिसाब से दो इन्फॉर्मिटी हैं। फर्स्ट, वी हैव रिमूव्ड द डिफरेंस ऑफ रिमिशन एंड कम्यूटेशन इन द न्यू प्रोविजन, क्योंकि उसमें हमने टर्म सेंटेंस को भी कम करने का कम्यूटेशन में प्रोविजन डाल दिया है। जबकि सीआरपीसी 1973 में टर्म सेंटेंस को फाइन में कम्यूट करने का प्रोविजन तो था, लेकिन टर्म सेंटेंस को 10 साल वाले को 3 साल में कम्यूट करने का प्रोविजन नहीं था। तो आई थिंक इट रिक्वायर्स रिविजन, और उसका कंफ्यूजन इसी वजह से है बिकॉज दीज प्रोविजंस आर हार्डली टॉट टू लॉ ग्रेजुएट्स, और इसमें प्रैक्टिस करने वाले लॉयर्स भी बहुत थोड़े हैं। तो ये केसेस बिफोर द कोर्ट प्रॉपर्ली रिप्रेजेंट नहीं हो पाते एंड डिफरेंट कोर्ट अंडरस्टैंड देम डिफरेंटली। So this is the reason we need to have a comprehensive judgment on all these provisions. अभी मैं एक प्रिजन ऑफिसर्स के कोर्स में था जिसमें तिहाड़ जेल में they told me that the court have ordered them in some case that under trial period में भी वो रिमिशन दें, जो जेल अथॉरिटीज रिमिशन दे देती हैं वो अंडर ट्रायल पीरियड की भी रिमिशन दे, which is I think is absurd.
Absurd.
So there is a need that all these cases, all these laws should be presented before some competent court, that is the Supreme Court, comprehensively, and let Supreme Court constitute a larger bench of, or rather constitutional bench, and decide these issues once for all. Because there is a lot of ambiguity and non-clarity even on part of the court on these aspects. I hope, Mr. Sastry, I'm clear, and we can discuss it one-to-one also if you want. Thank you.
Thank you so much, sir. I think it was quite a detailed, very informative response. One Mr. Charan Singh, I think wants to ask something. You have been unmuted, you can ask. आपको अनम्यूट कर दिया चरण सिंह जी, आप पूछ सकते हैं, हिंदी में भी पूछ सकते हैं, इंग्लिश में भी पूछ सकते हैं।
जैन सर।
जैन चरण सिंह
सर, एक तो वो तारीख वाला कह रहे थे सर, तारीख पे तारीख, इसमें 346(2) में सर पहले वो था कि सिर्फ मैजिस्ट्रेट ही 15 दिन से ज्यादा का रिमांड नहीं दे सकते थे। अब हर एक जज को बाउंड कर दिया सर 346(2) में कि 15 दिन से ज्यादा की तारीख अब कोई भी जज नहीं दे सकता सर। इससे भी सर ट्रायल जल्दी हो जाएंगे।
ठीक है।
BNSS में सर।
ये कहीं प्रोविजन डाले गए थे 2010 की अमेंडमेंट में, जिसमें एडजॉर्नमेंट का भी था कि एडजॉर्नमेंट नहीं देंगे।
हाँ सर, 346(2) में आ गया है सर।
बट दे आर हार्डली कंप्लाइड बाय द कोर्ट्स। ये सिर्फ मेयर सीआरपीसी में लिखी हुई डायरेक्शंस रह गई हैं, दे आर हार्डली कंप्लाइड विद द कोर्ट, बाय द कोर्ट।
सर एक सर जो कस्टोडियल डेथ का था सर, उसमें जुडिशियल वर्ड हटा दिया गया है सर 196(2) में, जो 176(1)(a) में था सर।
What is that?
तो अब हम सर क्या एग्जीक्यूटिव मजिस्ट्रेट से भी करा सकते हैं सर?
176(1)(a) जो पहले सीआरपीसी में हुआ करता था,
हाँ सर, उसमें जुडिशियल मजिस्ट्रेट ही कॉम्पिटेंट था सर, जो भी कोई कस्टोडियल डेथ या रेप इन कस्टडी में कोई भी चीज हो जाती थी। अब 196(2) है सर उसका, जो उसके पैरेलल बनाया गया है, बट उसमें जुडिशियल वर्ड हटा दिया है सर।
What is the definition of magistrate in CRPC or in BNSS?
सर मैजिस्ट्रेट की डेफिनेशन तो सेम है सर दोनों में।
दोनों में सेम है, but
सर
magistrate there means judicial magistrate as well as executive magistrate when they do certain duties which have been
Sir.
given in the CRPC,
राइट सर।
like under section 133 old CRPC, 107 CRPC.
जी सर।
So it should be interpreted as if judicial magistrate only, but let
Okay,
some
sir.
judicial interpretation come on it if it is, if the change is there.
सर एक इसमें एनएचआरसी ने भी सर अपना गाइडलाइंस तो जारी कर दिए हैं कि भाई एग्जीक्यूटिव से कराई जाए, उन्होंने 194 को भी इंक्लूड कर दिया है, बट ये हेजिटेशन है सर कि भाई अभी कराएं ना कराएं।
It is better कि judicial magistrate से कराओ, that is in your interest.
जी सर, जी सर।
Executive magistrate से तो हम पहले भी कराते रहे थे, 174
हाँ,
में भी
sir.
कराते ही हैं, तो it is
जी,
better
sir.
to ask the judicial magistrate.
हाँ, इन्होंने सर एक और कंफ्यूजन इसमें भी लास्ट में कर दिया सर, जो 196 का 6 लिखा है ना, उसमें लिख दिया, क्योंकि जब मैजिस्ट्रेट और एग्जीक्यूटिव मैजिस्ट्रेट ये दोनों डाल दिए हैं सर इसमें अपना सब सेक्शन 2 में, जो कस्टडी की बात करता है, तो यहाँ दोनों डाल दिए कि जो इंक्वायरी कर रहा है, तो यहाँ भी सर उन्होंने एग्जीक्यूटिव मैजिस्ट्रेट को इंक्लूड कर दिया है। यहाँ भी मैजिस्ट्रेट को उन्होंने डिफाइन नहीं किया सर कि मैजिस्ट्रेट सिंपल रहेगा, जुडिशियल रहेगा, और एग्जीक्यूटिव मैजिस्ट्रेट सेपरेट लिख दिया है, ये और कंफ्यूजिंग सा कर दिया सर। 196(6) सर।
So let us see how the court interpret it, but हमें we should go on safer side.
अभी हम जुडिशियली जा रहे हैं सर, तब तक नहीं होता तो।
और आपको एक चीज उसमें और आ जाती है, आपके 80% जो prisoners हैं they are under trial.
जी सर।
And section para 510 and 511 of Punjab jail manual अगर आप पढ़ेंगे, under
Sir.
trial is the property of trial court.
जी सर।
उनके बारे में कोई भी ऑर्डर अगर पास करेगी तो ट्रायल कोर्ट ही करेगी।
जी सर।
अगर उन्होंने कोई क्राइम भी कमिट कर दिया इनसाइड द जेल, so it
जी
will
सर।
not be an FIR case, it will be a complaint case, because
Right,
under
sir.
trial is the property of trial court and only trial court can pass any order against them. So therefore
Right, sir.
it is always advisable कि अगर अंडर ट्रायल है तो आप जुडिशियल मजिस्ट्रेट से ही कराइए। कन्विक्ट अगर
जी
है
सर।
तो लेट सम इंटरप्रिटेशन कम फ्रॉम द कोर्ट, टिल सच टाइम
Right.
द इंटरप्रिटेशन कम्स you should invite
जी
the
सर।
judicial magistrate only.
जी सर। सर वो डेजिग्नेटेड प्लेस यहाँ गवर्नमेंट ने नोटिफाई कर दिए हैं सर 31 जनवरी को, जेल्स में जो वीसी रूम लगे हैं दे आर डेजिग्नेटेड एज, वो जो उसमें है सर अपना बीएनएसएस में।
गुड, ये बहुत पहले हो जाने चाहिए थे।
हाँ सर, जनवरी 31 जनवरी को हुए हैं
हो
सर
जाने
ये।
चाहिए। यस
राइट सर, हो गए हैं सर।
यस,
जय हिंद सर।
धन्यवाद सर। मैं देख रहा हूँ चैट बॉक्स में तो करीब करीब सारे क्वेश्चंस एड्रेस हो गए हैं, और एक लास्ट अपॉर्चुनिटी हम दे सकते हैं। अगर किसी को और कोई क्वेश्चन पूछना हो तो या तो अपना हैंड रेज करें अथवा चैट बॉक्स में टाइप इन कर दें। So in that case, we presume that the audience, whoever wanted to ask questions in the audience, they've asked their questions. Or just a minute, I think one question has come from Sumit, Sub-Inspector. Sir, what is the role of IO/police if an accused is granted bail by the honorable court, but he hasn't furnished bail bond and he is in judicial custody and charge sheet has not yet been filed? Should I repeat, sir?
please repeat.
Yeah. What is the role of the investigating officer/police if an accused is granted bail by the court, but he has not furnished bail bond and he is in judicial custody? मतलब जो आदमी जेल में है, अगर कोर्ट ने उसको जमानत दे दी है और वो अपने बेल बॉन्ड फर्निश नहीं कर सकता है, तो आईओ या पुलिस को क्या करना चाहिए?
आईओ और पुलिस को उसका चालान कोर्ट में दे देना चाहिए। सेक्शन 190 सीआरपीसी जो है, जो कॉरेस्पॉन्डिंग टू सेक्शन 170 सीआरपीसी और 190 बीएनएसएस है, आप उसमें आयोग को ये क्लियर कर दिया गया है कि कोर्ट पहले क्या कहते थे कि जो बंदा है उसको प्रोड्यूस करो, हम चालान तभी लेंगे आपका, अदरवाइज वो चालान नहीं लेती थी कोर्ट। अब उस रिक्वायरमेंट को क्लियर कर दिया गया है 190 BNSS में कि विदाउट आस्किंग द पर्सन टू रिमेन प्रेजेंट इन द कोर्ट, द चालान कैन बी सबमिटेड बाय द आईओ टू द कोर्ट एंड कोर्ट विल एक्सेप्ट इट and then let him remain in the jail if he is not furnishing the bail bond. The trial will continue.
हाँ, रामाशास्त्री सर, आप कुछ कहना चाह रहे हैं क्या इसमें? Yes, sir, you can speak now.
Yeah. I hope I'm audible now. See, अगर जेल में ही है तो पुलिस हैज बीन टेकिंग एडवांटेज, रह जाएगा जेल में। आपका जो 90 दिन वाला भी जो भी बेनिफिट हो उनको नहीं मिलेगा, तो वो यूपी में रहा है। लेकिन एक रिलेटेड इश्यू है, जस्ट फॉर बेनिफिट ऑफ द अदर्स, वी वर डूइंग इन यूपी, कि अगर रेगुलर केसेस में ई प्रिजन्स में बेल ऑर्डर आ जाता है और इसके बाद रिलीज ऑर्डर भी आ जाता है, तो बेल ऑर्डर आ गया और रिलीज ऑर्डर नहीं आया तो फिर विद इन ए वीक, सत्पाल अंतिल के केस के बाद में एक वीक के बाद इमीडिएटली हम डिस्ट्रिक्ट डीएलएसए को इन्फॉर्म करते हैं, भाई ये बेल बॉन्ड नहीं दाखिल कर पा रहा है इसलिए तो वो रिलीज नहीं हो पा रहा है। तो फिर दे टेक इट अप विद द कोर्ट, dilute the conditions, or sometimes we are pitching in with MHA fund, जिसको कि श्योरिटीज वाला मनी इनको ग्रांट करेंगे, और अदरवाइज कोई एनजीओ या किसी को पकड़ते हैं इनको श्योरिटीज का अमाउंट और दाखिल करके दे देते हैं। दैट इज द सेकंड रिलेटेड इश्यू जिसको कि हम प्रिजनर्स को बेनिफिट दे पा रहे हैं। जस्ट लाइक टू फ्लैग द प्रैक्टिस।
Right,
It's
sir. Yes, sir. Sorry, sir. Please.
जो प्रोविजन अंडर ट्रायल के लिए जो जेल में है, why an under trial is in jail? He is by virtue of an order by the court. So any release order qua that person is to be passed by the court, और कोर्ट ही उसमें जेल सुप्रीडेंट को डायरेक्ट करता है कि ये इसको इतना बेल बॉन्ड एक्सेप्ट करके रिलीज कर दीजिएगा, या कोर्ट अपने आप कहता है कि आप बेल बॉन्ड यहाँ डालिए, और इसको जब वो दे देता है तो वो रिलीज ऑर्डर उसके जारी कर देता है। अगर वो बंदा नहीं कर पाता है, then Mr. Ramaशास्त्री has very rightly mentioned, if it comes to the notice of the jail superintendent, then he may write to the court that this is the situation, and if the court in their wisdom they think that the condition should be varied or changed, then the court is well within their right to change the condition. And under the Juvenile Justice Act, what Mr. Ramasastri has said, the provision, there is an express provision regarding that if a juvenile is not able to furnish bail bond, then within 7 days, if he is not able to furnish bail bond, the matter will be referred to the JJ board, and the JJ board will revise the condition of that person. So it is almost the same as Mr. Ramasastri has said. And if the jail superintendent comes to know about it and he has to accept the bail bond, then he should write to the trial court that the person is not able to furnish the bail bond.
थैंक यू सर। और मैं देख रहा हूँ कि अब कोई और क्वेश्चंस चैट बॉक्स में बचे नहीं हैं, और किसी का कोई रिक्वेस्ट भी नहीं है क्वेश्चन पूछने के लिए, तो हम अब इस सेमिनार को वाइंड अप करना चाहेंगे, समराइज करना चाहेंगे। सर, आपने बहुत ही मतलब पिछले 1 से ज्यादा घंटे में जो भी बीएनएसएस में ऐसे प्रावधान आए हैं, आपने शुरू से ही शुरू किया, डेफिनेशन से शुरू किया। आपने बताया कि नए एक्ट में बीएनएस में जो जेंडर की डेफिनेशन चेंज हुई है, जिसमें ट्रांसजेंडर को इंक्लूड किया है, उसका जेल के ऊपर क्या असर पड़ेगा, जेल में उनके लिए अलग से व्यवस्था करनी होगी, फिर उसमें मेल फीमेल को कैसे क्लासिफाई करेंगे, ये आपको ध्यान रखना होगा। और उसके बाद आपने कोर्ट्स के बारे में बताया कि अब हमारे पास यूनिफॉर्म सेटअप ऑफ कोर्ट्स हैं पूरे कंट्री में, उनका नोमेनक्लेचर को लेके आपने बहुत ही महत्वपूर्ण बात बताई ऑर्डर ऑफ सेंटेंसिंग के बारे में, कि पहले कंजुकेटिवली यूज्ड टू बी द जनरल रूल, और कोर्ट चाहे तो उसको कंकरेंटली भी कर सकता था, लेकिन अब जो है कोर्ट को अपने ऑर्डर में स्पेसिफाई करना पड़ेगा, क्योंकि कोर्ट को ये डिस्क्रेशन दिया है नए कानून ने कि ग्रेविटी ऑफ सेंटेंस को ध्यान में रखते हुए ये तय करे कि जो सेंटेंसिंग होगी, अगर मल्टीपल काउंट्स पे सेंटेंसिंग है तो उसका ऑर्डर कंजुकेटिवली होगा या कॉन्करेंटली होगा। और आपने जैसा बताया कि इन केस द जेल सुपरिटेंडेंट डजंट फाइंड दिस मेंशन्ड इन द कोर्ट ऑर्डर, देन ये उनकी ड्यूटी होगी कि वो कोर्ट में एप्लीकेशन लगा के इस चीज को क्लेरिफाई कराएं। इसी प्रकार से आपने कम्युनिटी सर्विस जो नया इंट्रोड्यूस किया है पनिशमेंट सेक्शन 4 ऑफ BNSS में, उसके बारे में भी जो डेफिनेशन थी उसको एक्सप्लेन करते हुए जो सेक्शन 23 BNSS में इसको डिफाइन किया, बताया कि किस नेचर का वर्क अवार्ड कर सकते हैं, कौन उसको एग्जीक्यूट कराएगा, उसको बेकार मानेंगे या नहीं। इन सारे इश्यूज पे अभी डेलिब्रेशंस चल रहे हैं, अभी पूरी तरह से क्लैरिटी नहीं आई है, बट वी होप कि जो नेशनल जुडिशियल एकेडमी में काम हो रहा है और वेरियस हाई कोर्ट्स आर सीज्ड ऑफ दिस मैटर, so as and when they will come out with the report, then perhaps there will be a better light on this particular issue. इसी प्रकार से हैंड कफिंग के ऊपर आपने बहुत ही अच्छा एक क्लैरिफिकेशन दिया कि जो नए कानून BNSS में चेंज हुआ है उसमें सर्टेन कैटेगरीज ऑफ क्राइम्स के लिए पुलिस ऑफिसर्स को तो ये पावर दिया है कि दे मे यूज हैंडकफ while arresting a person or while producing this arrested person in the court, but the same power has not been extended to the prison officers। तो उनके ऊपर अभी भी वही पुराना जो जजमेंट है सिटीजन फॉर डेमोक्रेसी वर्सेस स्टेट ऑफ आसाम एंड अनदर, वो कंटिन्यूड है, अप्लाई कर रहा है। तो आपको अगर हैंडकफ यूज करना है तो उसके लिए आपको स्पेसिफिकली कोर्ट से ऑथोराइजेशन लेना पड़ेगा। एक बड़ा महत्वपूर्ण जो परिवर्तन नए कानून में आपने बताया वो ये है कि अगर कोई इन्वेस्टिगेटिंग ऑफिसर जेल में आता है इन्वेस्टिगेशन करने के लिए, सर्च सीजर वगैरह करना चाहता है, तो उसके लिए उसको मोबाइल फोन का इस्तेमाल करना जो है वो अलाउड होगा। जो पब्लिक सर्वेंट्स इंक्लूडिंग प्रिजन ऑफिसर्स को अगर कई बार फॉल्स प्रोसिक्यूशन फेस करना पड़ता है, कंप्लेंट वगैरह मुकदमे दर्ज करने के आदेश हो जाते हैं, उसमें जो सेफ गार्ड नए कानून में इंट्रोड्यूस किया है इन सेक्शन 175, वो भी आपने अच्छे से एक्सप्लेन कर दिया है कि उससे उनको एक सहायता मिलेगी कि बिफोर द कोर्ट कैन ऑर्डर दे विल हैव टू ऑब्टेन a report from their superior officer, as well as they will have to also provide an opportunity of hearing to the concerned prison officer or the police officer। और इसी प्रकार से आपने जो बताया दूसरी चीज है कि कॉपीज ऑफ द एक्यूज को देने का आप क्लियर कर दिया है, जो कंफ्यूजन था पहले 207 में। और अब ये ड्यूटी जो है पुलिस ऑफिसर्स की कास्ट की है कि इट इज द ड्यूटी ऑफ द पुलिस टू प्रोवाइड कॉपीज ऑफ डॉक्यूमेंट्स टू द एक्यूज्ड पर्संस। यहाँ तक इलेक्ट्रॉनिक माध्यम से रिकॉर्ड करने का सवाल है, एविडेंसेस ऑफ विटनेसेस एंड एक्सपर्ट्स, तो ऑब्वियसली उसमें आपने बता दिया है कि थोड़ा वारंट केस के लिए तो उन्होंने लिख दिया डेजिग्नेटेड प्लेसेस, और वो अगर प्रिजन से हमको कराना है तो उन प्रिजन को हमें डेजिग्नेटेड प्लेस जो है नोटिफाई कराना होगा। और एक्यूज्ड के भी सारी काम जो है वो अब प्रिजन से हो सकती है, आपको उन्हें अदालत में ले जाने की जरूरत नहीं है। केवल एक चीज के लिए एक्यूज्ड को फिजिकल प्रोडक्शन जो है वो जरूरी है, दैट इज व्हेन द पुलिस इज सीकिंग देयर पुलिस कस्टडी रिमांड, देन द एक्यूज्ड हैज टू बी प्रेजेंटेड इन पर्सन। अदरवाइज बाकी सारे काम जो है एक्यूज्ड के, इंक्लूडिंग चाहे उनके चार्ज फ्रेम हो रहे हो या उनको पनिशमेंट सुनाया जा रहा हो, उस ये सारे काम भी जो है वो ऑडियो वीडियो से भी हो सकते हैं। आपने सेंट्रल और स्टेट गवर्नमेंट के जो पावर्स हैं कि ये जो कि भाई अगर कोई मान लीजिए ऐसी बात है, लॉ एंड ऑर्डर वाला इश्यू है और अगर कोर्ट का आदेश आया है कि इसको लेके आइए, तो पहले केवल स्टेट गवर्नमेंट को ये पावर था, अब सेंट्रल गवर्नमेंट को भी ये पावर आ गया है। 336 एक बहुत ही महत्वपूर्ण प्रावधान है जिसके बारे में आपने अच्छे से बताया है कि जो एक्सपर्ट लोग हैं, पब्लिक सर्वेंट हैं, उनकी रिपोर्ट है, उनके डॉक्यूमेंट हैं, उनको लेकर के अगर एविडेंस में उनकी आवश्यकता पड़ती है, तो अब क्या चेंजेस हुए हैं कि अगर कोई रिटायर हो गया है, जो मिल नहीं रहा है या डेथ हो गई है, तो उसे ना बुलाया जाए, उसके स्थान पर जो व्यक्ति अब काम कर रहा है उसी अधिकारी को बुला लिया जाए, और जहां तक संभव हो उनको फिजिकली नहीं बुलाया जाए, उनकी एविडेंस भी जो है वो ऑडियो वीडियो इलेक्ट्रॉनिक माध्यम से हो जाए। तो ये इसमें आ गया है। इम्पोर्टेंट चीज ये है कि आपने जो रेमिशन और कमिटेशन के बीच के जो कंफ्यूजन्स हैं, जो गैप्स हैं, जो डाउट्स रहते हैं, उनको बहुत ही विस्तार से बहुत अच्छे से सबको एक्सप्लेन किया है। आई एम वेरी श्योर आवर ऑडियंस मस्ट हैव बीन बेनिफिटेड एंड गॉट वेरी आई मीन गुड क्लैरिटी ऑन दिस कॉन्सेप्ट्स, कि इनका कॉन्सेप्चुअल क्लैरिटी क्या है, उसके अलावा इनकी एप्लीकेबिलिटी को लेकर के जो इश्यूज हैं वो क्या है। सेक्शन 479 जिसकी काफी चर्चा हुई और रामा शास्त्री साहब ने भी उस पे अपना ऑब्जर्वेशंस दिए। मैं समझता हूं कि अधिकारियों को काफी क्लैरिटी आई होगी, लेकिन इसमें फिर भी जैसा बताया गया है, जिस तरह से ये ड्राफ्ट किया गया है, उसमें थोड़ा सा इंटरप्रिटेशन को लेकर के इश्यूज हो सकते हैं और हमें वेट करना होगा कि इसमें जो कोर्ट्स का क्या रुख रहता है एंड हाउ अल्टीमेटली इट इज इंटरप्रेटेड एंड अप्लाइड, वो इश्यूज रहेंगे। बाकी जो मर्सी पिटीशन है, विड्रॉल फ्रॉम प्रोसिक्यूशन से रिलेटेड जो प्रावधान है, पर्टिकुलरली विक्टिम को सुनने का जो पावर दिया गया है कि भाई कोर्ट जब तक विड्रॉ नहीं करेगा, जब तक विक्टिम को नहीं सुने, इन सारे इश्यूज पे भी आपने बहुत ही विस्तार से बताया है। और मुझे धन्यवाद देना होगा हमारे ऑडियंस का, जिन्होंने रैप्ट अटेंशन के साथ इस प्रोग्राम को सुना, स्पीकर को सुना। और आई कैन सी some of the audience have given their comments in the chat box also. They have appreciated the speaker and conveyed their gratitude and thanks for such a lucid, very well explained in a very simple language, easy to understand way, the various provisions of the law relating to prison administration as it has been incorporated in the BNSS. तो काफी मैं समझता हूँ कि संतुष्टि है जिन लोगों ने पार्टिसिपेट किया है डिस्कशन में, क्वेश्चंस पूछे हैं और इस वेबिनार को एनरिच किया है, उनके प्रति हमारा विशेष आभार है। और हमें धन्यवाद देना होगा हमारे प्रेसिडेंट साहब का, श्री एन रामचंद्रन साहब का, जिन्होंने इनिशिएटिव लिया इस वेबिनार को आज आयोजित कराने में। और मैं समझता हूं कि ये बहुत ही महत्वपूर्ण उपयोगी वेबिनार रही होगी आप सब लोगों के लिए। आप लोगों ने फीडबैक फॉर्म भी अपने कई लोगों ने भर दिए हैं, जिन्होंने नहीं भरे हैं वो बाद में भी भर सकते हैं, वो हम लोग उसके लिए अरेंज किया जा सकता है। तो आई थिंक वी हैव टू एक्सप्रेस आवर utmost gratitude and thanks to today's speaker Dr. KP Singh, that not only that he spared his valuable time today, but I think the presentation was written in a very simple, easy to understand language, और सर के जो एक्सप्रेस करने का तरीका था, एक्सप्लेन करने का जो तरीका था, बहुत ही सिंपल था। और मैं समझता हूँ कि हम सबको बहुत ही आसानी से समझ में आया और बहुत सारी चीजें जो शायद पहले क्लियर नहीं थी वो आज के इस वेबिनार से क्लियर हुई है। और ऐसी उपयोगी वेबिनार का अगर आप लोगों का और कोई रिक्वेस्ट हो आगे भी फ्यूचर में, तो आप लोग जो है इंडियन पुलिस फाउंडेशन को लिख सकते हैं। हम लोग प्रयास करेंगे कि उसके लिए जो अप्रोप्रिएट एंड द बेस्ट स्पीकर जो भी हमें मिलेंगे टॉपिक्स पे, उनको हम लाने की कोशिश करेंगे आप लोगों के सामने। और इसी प्रकार की और वेबिनार भी हम भविष्य में आयोजित कराना चाहेंगे। आप सब अधिकारी जो प्रेजेंट हुए उनका बहुत बहुत धन्यवाद। आपके सुपीरियर ऑफिसर्स, डीजी प्रिजन्स एंड डीजीपीज एंड ऑल दी other officers who allowed you, who nominated you for participating in today's webinar, इंडियन पुलिस फाउंडेशन की तरफ से मैं उनका बहुत बहुत धन्यवाद करता हूँ। और आशा करता हूँ कि एंड आई थिंक द साइज ऑफ पार्टिसिपेशन हैज बीन क्वाइट एनकरेजिंग। एट वन पॉइंट ऑफ टाइम द नंबर ऑफ पार्टिसिपेशन रीच्ड ऑलमोस्ट अप टू 400। तो हमने पहले थोड़ा ये एक्सपेक्ट नहीं किया था कि इतनी अधिक संख्या में लोग इस सेमिनार में भाग लेंगे, इसलिए जस्ट बिफोर द सेमिनार बिगेन हमने इमीडिएटली बात करके और उसके पार्टिसिपेशन की संख्या को बढ़वाया। इसीलिए जो है इसमें 400 के करीब लोग जो है इस वेबिनार में भाग ले सके। Dr. KP Singh and Ramchandran and all of you who participated in the seminar, once again on behalf of the Indian Police Foundation, I express my gratitude and thanks to all of you. I think if anyone has to say anything, otherwise we may call it a day. Thank you.
Thank you, Dr. KP Singh, for such a rich and wonderful exposition. And also thanks to our COO, Shri DC Jain. Both of you have made this a very worthwhile time for all the officers who have been present here. Thank you very much.